discussion that will be done by Pam McDonald. Pam McDonald is a fellow certified HR professional who brings change management and training expertise along with her experience of HR management skills. Known for her passion and clear style, Pam has supported many business owners in navigating the increasingly complex industrial relations environment. Her practical advice is delivered with care and concern for the employer and the employee because she believes that great people equal great business. Pam, the floor is yours, and please share your wonderful screen with us.
Thank you so much for the introduction and the welcome. It's great to be here. Let me just make sure that I've got my slides. What I would love to cover with you in the next 10 minutes are some of my top HR hints for small business. As I said in my introduction, or as Paulina beautifully said in my introduction, it is an increasingly complex industrial relations environment in Australia, to the point that many business owners that I speak to are starting to challenge their growth plans because they know that growth means that they have to bring on staff. And they're looking at all of these changes that are coming on and they're saying, I just don't want to do it. It's too hard. We've got changes to rules about casuals. We've got changes to rules about contractors. So people are really starting to worry about how they're going to sustain and grow their businesses because the ways that they've been doing things feel like they're not quite right. So what I'd like to do today is take you through some of my top hints and some of the key questions and some of the key concepts to get in mind, particularly if you're in that position of bringing on your first employee, because that should be an exciting time. Before you bring on your first employee, there are some must-have documents. You really cannot enter into employing staff unless you have a written employment contract. Now, this is where a lot of small businesses go a little bit off the rails. They bring somebody on, they have a handshake agreement. The challenge with that is that when things go astray, as they sometimes do, where's your document that confirms what it was that you agreed to, what it was that you didn't agree to? And from a Fair Work perspective, they will take a verbal agreement as having exactly the same legal standing as an employment contract. And most times they will look to protect the aggrieved employee, which means that as the employer, you can find yourself in a position where you had an agreement, things had moved and changed. You thought things were going well until they weren't. And then you have an issue with Fair Work, and what actually gets put into place and what gets enforced is the verbal agreement as it was understood by the employee, not as it was understood by you as the employer. There are some things that your employment contract really also needs to be supported by, and one of those is a code of conduct. Not necessarily a really long document, but absolutely something that sets down in writing your ways of working. Can be your values. It can be things like, this is how we treat each other. It doesn't overwhelm or overstep any of the policies that you need to have to prevent bullying, harassment and discrimination, but a code of conduct is a really good platform to support those policies. In these three areas where I'm saying you have to have policies, even if you have one employee alongside you, the reason for that is that there's a concept called a positive obligation that now exists in the legislation. What that means is that employers have to show evidence that they have taken all reasonable steps and actions to prevent bullying, harassment or discrimination from happening. There's an example of a very small business in Melbourne in hairdressing who had clear policy, who had clear employment contracts, who had a good code of conduct, and still fell foul of the rules because the one thing that they hadn't done was followed that up with training and confirmation that the employees understood what their obligations were in terms of having a workplace that's free from discrimination, bullying and harassment. So you think about a small business, a hairdresser who's got 3 or 4 staff and they've gone through all of those steps and was still found wanting. So these must-have documents are a framework, but it's also, as I said at the start, an increasingly complex environment. Thinking along those lines, it's also really important to have a protocol for how you're going to handle grievances and how you're going to manage performance, particularly performance that's not quite right, but it's also useful to understand what you're going to do when performance is really good. For me, one of the challenges that we often have in a HR environment is that people focus on the negatives. You need to have guidelines, because if you give somebody feedback that they've done a really fantastic job, in a lot of people's minds, that automatically means a 5 or a 10% pay increase. That might not actually be feasible, viable, realistic for your business. So if you have a process and an approach for how you manage performance documented, then that really will help clarify that, just like clarifying what you've agreed in an employment contract. The importance of having a grievance handling process is making sure that you've got something that's set up, that's structured, so that people know what to expect before things have gone off the rails. One of the worst times to try to navigate conversations and discussions and facts with people is when they're already upset and emotional. So those are what I view as the key must-have documents. Another thing that's really important to understand is that in our environment, we've been hearing and seeing a lot of focus on employee rights. I often say to my clients, I feel a bit awkward because we've done such a good job communicating what employees' rights are and such a lousy job communicating what the responsibilities that they have and also what rights employers have. So here are my 3 key areas. You have the right to make adjustments to the workplace and to someone's role that are reasonable. Now, I have reasonable in quote marks on the screen and in me, because reasonable is a flexible definition that depends on the size of your business. So if you think about somebody who works for one of the major banks and asks for a stand-up desk to be provided, if the employer said no, that's not reasonable, because they're big, they've got huge scale, they've got deep pockets. But if you have one person working for you and you're working from a home office and they've asked for a $3,000 stand-up desk, that might not fit the definition of being a reasonable adjustment. Employees have the right to make certain requests, but that does not mean that you must comply or agree to that request. Again, it comes back to what's reasonable. You have responsibility, though, with certain requests to respond within a certain time frame and in a certain way. But the employees do have the right to request flexible work arrangements, including working from home. But you as an employer, particularly if it's your first employee, and particularly depending on the nature of the work, you don't have to agree to that request. And this last one is one of my favourites. As an employer, you have the right to assess and confirm that an employee has the capability to fulfill the inherent requirements of the role. That's a really key phrase, because you can assess what their skills are and what their capacity is, but it has to be about the inherent requirements of the role. Not, you can't do a fitness test on me in a lot of desk-based jobs, but you could do a fitness assessment on me if I was to be a courier driver for you, where you were employing me to be in and out of a vehicle all day. I'm hoping we'll have some time for questions at the end as well. One of the things that I really want to do is to bust a myth. The biggest myth that I hear in HR and managing staff is that you need 3 warnings before you can terminate employment. No, you do not need 3 warnings to terminate employment. Serious misconduct is something that's very different, that can result in an instant dismissal. But in terms of terminating of employment, there are some things that you do need. And you need to have clarity on what was expected, a clear statement of what was done or not done that missed that level, and evidence of conversations and support that you've provided to the employee to get them to improve to deliver that standard. So if you do 3 warnings, and you don't have those 3 key points, you can still be at risk of an unfair dismissal claim. So my big myth, you don't need 3 warnings to terminate, but you do need good process and clear communication about what was expected and what was given. There's a really great small business dismissal code that's available for free from the Fair Work Ombudsman that is very helpful. Remembering, folks, that under the Fair Work legislation, a small business is one that has less than 15 employees. So if this is your first employee, well, you're definitely a small business. And as we reach the end of my 10 minutes with you today, I wanted to wrap up with where you can get some help from. Now, Small Business Victoria have a great set of HR policy templates. Absolutely encourage you to have a look at those. And if anybody wants the link, I'm happy to send that directly to you. You can get a lot of information from the Fair Work Ombudsman site, including that small business dismissal code. But you've got to be careful because information is not necessarily going to give you advice or guidance. We do sometimes have challenges with how information is interpreted. And of course, engaging a good employment lawyer can be really, really effective. And I have a few really good employment lawyers that I work with. The challenge, though, is that for many of them, they will charge you $3,000 to write an employment contract. And I don't know how many of us would have that much money sitting in a pocket when we're going through the process of setting up our business with our first employee. So one of the things that I have done is that I've got a small business starter pack where I go through a checklist of what needs to be in your employment contract, provide a template for a code of conduct, and we'll spend half an hour on the phone with somebody helping them work through and navigate that process of employing their first employee, because that, as I said, that really should be an exciting time for your business, not something that fills you with dread. So there you go, folks. In 10 minutes, rapid fire, some of my top tips for small business in terms of HR. I hope that that's been useful and helpful, and I'll open to questions or we'll wrap up our recording.
Thank you, Pam. This has been absolutely fantastic. For those that are watching online, there'll be Pam's details below the video. Please reach out to Pam, and I'm sure she's got lots of other tips to share.